Welcome back, students. In the last part we had discussed about intention, how intention is relevant in culpable homicide, and also we discussed about different degrees of intention, right, and that is vital to invoke section 299 in an appropriate cases, right. And in this particular session we are going to discuss about knowledge, right. As we know that we discussed under section 299 that knowledge is one of the element under section 299, or I would say that it is a minimum requirement or the least degree of intention which is required in order to make an act under what a culpable homicide or under section 299 of the Indian Penal Code, right. So, if you ask a question, what is mean by a knowledge, I would say in a jurisprudential term, knowledge means it is a state of consciousness of certain facts, consciousness of human minds, right, about a particular fact in which human minds remains inactive, right. This is called in jurisprudential term we call it as a knowledge, the consciousness of mind. So, it is presumed that whoever is doing certain act, suppose in the case of 299, if a person is doing certain act, he is expecting certain consequences, probably that he is expecting the death of the other person, right, and even if he does not have an intention to kill the other person, right. This is in the context of section 299. In a general term you can say that whoever does an act is expecting certain consequences. So, in order to invoke section 299, whoever does an act, probably he would expect the death of the other person, right. See, the word likely under section 299, it shows the least possibility, even though a person does not have an intention, right. It shows that a person, a conscious mind, right, a person who is doing an act with a conscious mind should reasonably expect certain consequences or should reasonably expect the death of the other person, right. Then it can be invoked, section 299 can be invoked. This was held in Rajpal versus State of Haryana. The Honorable Supreme Court said that if a person, a conscious mind is doing certain act, right, then it can be presumed that the conscious mind is expecting the death of the other person. The word likely denotes the possibility, right, the least possibility. It denotes the least possibility of the person, or it shows the sense of probability. The word likely denotes the sense of probability. There is one English case, R versus Cunningham, right. In this particular case, there was a fight between the victim and the accused person. So, in a fight we know that there was an immediate provocation, and in this guy, the accused person who hit on the head of the victim with a chair, right, and he does not have an intention to kill the other person, because since it was a sudden fight, he reacted in that way, right. The question was whether it can be considered as a as a culpable homicide or not, or whether he have an intention to kill the other person or not. In this particular case, the Honorable English Court, right, it held that this person committed the offence of culpable homicide because because he caused a grievous hurt to the other person, right. When a person is causing a grievous hurt, it is there is a high probability that this person is expecting certain consequences or the death of the other person. See how the court has been interpreting things, right. So, there the court said that yes, it is a fit case to invoke the concept of culpable homicide or the offence of culpable homicide. So, it has been invoked and the person has been convicted. In another case, in Cunliffe versus Goodman, right, and it explained what is mean by intention. It's very, that case is very important in terms of intention. It says it connotes a state of affair which a party intending or does more than merely contemplate. It connotes a state of affair which on the contrary he decides so far as in him lies to bring about. So, this definition is very important. Its intention is a state of affair which a party is intending, right. So, this is very important. And if you ask another question, right, what is the difference between an intention and knowledge, right, this is a very, very important, right, because even sometimes I am also confusing what is meant by an intention and knowledge. So, here there is one prominent case in Basdev versus State of Pepsu. It was a 1956 case, right. It was held that, right, motive is something which prompts a man to form an intention. Knowledge is an awareness of consequences of act. So, it is very important. So, within quotation it says that motive is something which prompts a man to form an intention, right, whereas in the case of knowledge it is an awareness, right, it is very important, awareness of consequence of an act. In many cases intention and knowledge merge into each other and mean the same thing more or less, and intention can be presumed from knowledge. The demarcating line between knowledge and intention is no doubt thin, but it is not difficult to perceive that they cannot different things. In another case, R versus Nedrick is an English case. Again, the Court of Appeal held that knowledge or foresight of probable consequence of an act cannot take the place of intention. Further, the court added, with regard to the mental element in murder, a jury is merely required to determine whether, having regard to all the circumstances including what he said and did, the defendant intended to kill or do serious bodily harm. It followed that the judge's discretion was wrong because it equated foresight with intent, whereas foresight of consequences could be only evidence of intent to commit murder. This case is also very important with respect to knowledge. Knowledge is a strong word and imports certainty. I said the word certainty because it is very important, because in the previous sessions we have discussed that like the word likely denotes probability. So, once the likelihood has been proved before the court of law, this probability will be converted into what intention. So, it does not mean that knowledge always shows the probability. In the first stage, the knowledge it can be considered as a probability, but later it is not a mere probability, it attributes intention. So, that is very important, right, and this was held in by Honorable Supreme Court in Hiraji versus Kuber Singh. It was held that knowledge is a strong word and it imports certainty, and it is not it works on the basis of what certainty. So, it shows intention. See, a death may be caused either by commission or omission. So, certain times omissions is also treated as a as an what knowledge or as an intention, because when you will take as an omission, because it says that if a person is having a legal duty to perform or to do it and he committed omission, then you have to attribute intention, or let me say the word knowledge. So, let us say for example, the duty of husband towards wife or the duty of children towards parents, right. So, here it is coupled with both legal as well as moral duties. In R versus James Shepard, in this particular case the parents were convicted on the basis of culpable homicide. The child was sick, and because of the poverty they could not take the child to the hospital, and the second appeal court convicted the parents, because the parents is having what certain aware about the health of the child, and the court convicted the person. But when the matter went to the House of Lords, the court said that in order to convict the parents, the first requirement is that you have to prove that the parents were the parents is having a knowledge that the health condition of the child is so bad, right. If you are not proving the knowledge part of the parents, then you cannot invoke what the culpable homicide. This is a very important case. The House of Lords quashed the conviction and held that what mens rea is necessary to prove the guilt of the person. So, in order to prove the mens rea, what is required under section 299 or under the concept of culpable homicide, you have to prove the knowledge part or the awareness part. So, here in this particular case, the awareness concept is lacking, and hence this case has been reversed. In Directorate of Public Prosecution versus Nobry and Johns, killing by gross negligence, as I said, omissions, as I said, commission and omission can be invoked when there is, legal obligation. So, gross negligence, right, it is also treated as a culpable homicide. So, that is very important when a person is having a legally bound, if a doctor is not conducting surgery on time and a death is caused due to the omission or the negligence, right, in such a cases 299 can be invoked, right. And also at the same time, we know recently there are police encounters are happening, right. So, what is a criminal liability in this particular case, and police encounters are happening in the pretext of criminals, because criminals are happening, right. Recently in Delhi also it happened. So, in this particular case, right, if a question comes whether what the police officers who is engaged in the police encounters, whether they are aware about the consequences, right. In this particular case, very important case in Brijlal Verma versus SPCBI, it was adjudicated in 2001. The Honorable Supreme Court, the Honorable High Court, Allahabad High Court held that anguish, first the court expressed the anguish over the police encounters, and the court said that the police encounters are nothing but murders, and the guilty police officers are what deserves death penalty, right. That means a person or the police officers who is engaged in the police encounters on the pretext of encounters, that in such a cases, if it is not otherwise, then the police officers are entitled to receive punishment. It amounts to murder. So, that is very important term, right. So, the difference between the culpable homicide and murder. Let us look at the punishment under the Indian Penal Code, the various categories of punishment, as I said, the first degree, second degree, third degree. Let us look the Indian Penal Code, what are the different range of punishment that is prescribed under the Indian Penal Code. Look at section 308. It prescribes punishment for what attempt to commit culpable homicide. What is the punishment? 7 years of imprisonment, rigorous imprisonment, fine or with both, right. Then look at section 304 of the Indian Penal Code, punishment for culpable homicide not amounting to murder. As I said, there are two classification of culpable homicide amounting to murder, not amounting to murder. Here it is not amounting to murder, the maximum punishment is 1 year of simple imprisonment, fine, or sometimes it will be with both imprisonment and fine. And look at section 307, it gives attempt to murder, right. What is the punishment? Life imprisonment or any other punishment which is prescribed in the presiding section. That is section 307. See, on the basis of the imposition of the punishment under these sections or different categories of section 209, 304, 307, 308, all these sections, if you look at, there are different degrees of intentions prescribed in 299 or the presiding sections, let me say 304, 307, 8, right. So, listen, what it talks about, all it talks about, or let me say the entire Indian Penal Code classifies into 2 degrees of intentions. Let me say the first part prescribes a sentence of imprisonment for life or imprisonment for either description of a term. The either description of a term. What is meant by either description of a term? It denotes both simple imprisonment or rigorous imprisonment, right. It is the prerogative of the court. The court can direct either simple imprisonment or rigorous imprisonment, that is called either description of a term, right. So, it says about any sentence right, either description of a term of 10 years or fine, right, what does it mean? Which the death is caused is done with intention of causing such death, right. And here this part clearly denotes what the intention of the person, right. As I said, if a person, the court can impose, right, life imprisonment or death penalty, right. What does it mean? It means that, or death is caused in that particular case, it simply says that the person is having an intention to cause death of the other person. It shows a high degree of intention, right. The second part applies to the offence where the act is done with the knowledge which is likely to cause the death of the other person. So, first part is with a higher intention to kill the person. Second one is the person is having the knowledge that it may likely to cause the death of the other persons, right. Let us say the offence under section 304, right. It is a higher degree than, when compared with the other degrees of intention, right. If you take section 307 and section 308 of the Indian Penal Code, what it talks about, it talks about a minimum, a less in a degree of intention. Let us look the difference between murder and culpable homicide. See, in the case of culpable homicide, if you take the first part, right, what is the first ingredient under section 299? With an intention of causing death. This is what the first ingredient under section 299. If you look at murder, it simply says that with intention of causing death, right, then what is the second ingredient? This is with the intention of causing such a bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. This is the first ingredient. The second one is with the intention of causing such a bodily injury as it likely to cause death, right. This is under culpable homicide. But if you go to murder, the same situation and the bodily injury, right, indeed to be inflicted is sufficient in the ordinary course of nature to cause death. In the ordinary course of the nature, if such a bodily injury is sufficient to cause the death of the person, then it will be treated as a murder, right. The third difference is with the knowledge that that act is likely to cause death, right. Here in the case of murder, with the knowledge that the act is imminent, that it must in all probability causes death or such a bodily injury as is likely to cause death and committed without any excuse for incurring the risk of causing death or such injury. This is important. So, these are the fundamental differences between murder and culpable homicide. Let us go to the conclusion part. I hope this lecture would help you in differentiating what are murder and culpable homicide. So, let us conclude about this lecture. See, as I said in the first session itself, I mentioned section 299 talks about culpable homicide, or let me say the Indian Penal Code does not define what is culpable homicide or what is murder, right. It talks about certain, let us say in the case of, at least in the case of culpable homicide, right, it is not defined anywhere. So, the fifth law commission recommends to redefine the concept of what is, whatever it is in the IPC, it should be redefined. A concrete definition should be given to the culpable homicide. Unfortunately, the definition is not yet incorporated, right. And another one is, the law commission also recommended punishment for culpable homicide. It simply says that what a 10 years imprisonment has to be provided, right. It has been said that the life imprisonment which is never awarded to culpable homicide, right. So, in the place of life imprisonment, a term up to 10 years should be provided for culpable homicide. But unfortunately, the definition part as well as the recommendation by the law commission with respect to the 10 years of imprisonment, which is not incorporated in the Indian Penal Code. That is all. Hope that this lecture would help you in understanding culpable homicide, how the intention part has to be identified, how the intention and knowledge differs under section 299, and we have discussed with a few English cases also, right? And also I hope you would be in a position to differentiate between culpable homicide and murder. Thank you.